Welcome, everyone. My name is
morning,
Marilyn
Marilyn.
Petito Devaney, and I will be presiding over the hearing for Attorney Maureen Mulligan. So I welcome you.
Thank you.
Attorney Mulligan. And we do have 3 counselors in the State House that I would like to introduce first, and then people on Zoom. To my left, Councilor Ferreira,
Thank you, Madam Chairwoman. Good morning.
Councilor Kennedy,
Morning.
and Councilor DePaula. And on Zoom, we have, we have Councilor Duff. We have Councilor, very hard to see on Zoom, Ianella someplace. Oh, I just want to
I'm
mention that
actually on the
Councilor
phone.
Ianella is having difficulty, and so with the computer, so he will be calling in. And so,
I'm here.
do we have Mary
I'm here.
Hurley?
Yes, you do.
Okay, wave, Mary, I can't see you. Okay. And
Marilyn, can you hear me? Marilyn, can you hear me?
very hard to hear. Is anyone having trouble hearing?
That's Chris. I can hear him. We can
Yeah, I
hear you.
just want to, Marilyn, I'm here. I'm on the phone, but thank you.
Okay, and Councilor Juvenville,
Yeah, good morning.
did I miss anybody?
No.
Okay, so I'm going to, before I begin, I do want to say that years ago, the Governor's Council voted to have people sworn in who are going to speak before the council at the hearing. And I was one of the members also. So I ask you to take, if you would please stand in, if you can, and swear to tell the whole, swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Okay? All right, so, all right, having said that, my other thing is I'm going to ask everyone to put away their cell phones in respect to the nominee, in respect to the importance of this hearing. And having said that, I'm going to open the hearing. And I will start with Attorney Mulligan's witnesses. And the first witness is Judge Janet Sanders.
Good morning, everyone. I think I was last before some of you almost 20 years ago. So it's good to see some of you again. There, of course, I was in the position Maureen is in today, seeking your approval. And so it's a real delight for me to be here and speak in support of her. I've known Maureen Mulligan for almost a decade. She's appeared before me many times in the business litigation session at the Superior Court, where I've sat for the last 9 years. And she's really stood out from other civil litigators, not only in the depth of her legal knowledge, but also in her temperament. Her legal writing is crisp, it's to the point. Her oral presentations are no different. They're complex, she can, very concise. She can take very complex legal questions and explain them in a way that's understandable. And I've never seen her lose her cool. She is in command at the same time that she treats everybody in that courtroom with courtesy and respect. And so these are all qualities that I think will serve her very well as a judge. Unlike many civil attorneys, Maureen is also a skilled trial lawyer. A few years ago, she tried a 2-week case to a jury involving a complicated stock dispute between members of a close corporation, what we call in the corporate word, a corporate divorce. They really hated each other. She not only had a solid grasp of the rules of evidence, but she knew her way around the courtroom. I witnessed her deftly cross-examining the witnesses. She used hundreds of exhibits to educate the jury to her point of view. And at the same time, she educated me, not by hiding the ball, but by dealing directly with the legal issues that arose. She was the kind of lawyer that I could trust to give me an honest answer. And as I said, the litigants hated each other, but Ms. Mulligan always was totally professional. She advocated without to some degree, getting involved in their own emotions. I know that some of you may have some questions about the fact that Maureen has little experience in criminal matters. That is not something that, in my view, will keep her from being a great judge. In fact, that civil background will prove very valuable to her in performing her judicial work on the Superior Court, since the majority of our caseload, well over 50%, is in fact civil in nature. And those civil cases are very often quite weighty. So for example, in the business litigation session, where Maureen, I think ultimately after a few years of learning how to be a judge in other sessions, she would be a perfect addition. The cases we preside on include disputes between businesses, but also over large consumer class actions, claims asserted under the Massachusetts Wage Act, suits both by and against the government. And in regular civil sessions, judges preside over medical malpractice cases, employment discrimination claims, and product liability suits. The decisions rendered in these cases often have an impact well beyond the parties to the dispute. So it's really critical that we have judges amongst us with the background and experience to deal with these civil matters in a way that's fair to all. And Maureen has all of that. Let me also point out that the nominees you have approved and who've gone on to be excellent judges have come from a wide variety of backgrounds. So some arrive to the bench with little or no experience in civil litigation. They grow into the job, however. They learn to handle a full docket of civil cases. Others have little or no experience in criminal work. They have been able to master the legal principles necessary to decide those criminal cases and to do so without a bias in favor of either the prosecution or the defense. So how is that possible? Well, it's in part because in Superior Court, we do have a rigorous training program for new judges. That program pairs every new judge with a more senior judge as a mentor. The program also includes peer observation, monthly educational seminars, and a new judge school. And our chief is also very careful in her assignments to those new to the bench so that nobody is thrown into the deep end until they're ready to swim. But I think more important than that, it's each of the judges that you have approved and that have gone on to do their jobs well share something in common. They have intelligence, they have commitment, the patience and the humility necessary to do the job well. Those are the qualities that you should be looking to in making your decision as to whether to approve a judicial nomination. And I'm quite confident that Maureen Mulligan has all of those attributes. So I ask that you please confirm her. You really need people of her stature and experience in the Superior Court. So thank you.
Thank you, Judge Sanders. I can't tell you how honored I am to see you. It's been a long time.
It has been.
And for people that are tuning in, I had the honor to vote for Judge Sanders 20 years ago when you were a district court judge in Concord. And I don't want to embarrass you because I know how humble you are, but I would be remiss if I didn't say the following. You had your witnesses lined up, and I had got a call a couple of days before the hearing, and it was from the custodian of the Concord District Court. Let me see, what was his name? Is Dan. Dan? Was it Dan?
Yeah.
And I'm telling you, in my 21 years, he is on the top of my respectful list of people who testify. And he said to me, I have been a janitor here in Concord District Court for 32 years. I don't get involved. I'm not involved in any of the appointments here. But I have to tell you that Janet Sanders is the most compassionate, kindest person that I have ever met. She cares about all of us who work in this court, besides how the kindness that she shows to the people who appear before her. He said a lot of nice things. It's hard to remember, but I'll tell you, I was so moved. And I said to him, would you come in and be a witness and say it publicly? Oh, no, I couldn't do that. He was a very shy person. But I'll tell you, after your witnesses spoke, I remember saying, I don't want to demean the great witnesses that spoke on your behalf, but you had the most outstanding witness that called me. And I proceeded to say what he had said. Dan Clinton, am I right? Is it Dan Clinton?
You know, this is
That's a
he
long
never-
time for me to remember.
and he-
But
no,
anyway.
he never told me he did that. He never told
No,
me. It was totally
no, he,
unsolicited.
very
And I'm finding
humble
it right
person.
now.
But I said, I'm sorry, but I have to say, that is the best witness that I have ever heard. And of course, I was, you know, I wasn't a seasoned counselor. I, you know, that was, you know, just, I think, my second term. But I will never forget that, and I will never forget you, because to have someone like you on the bench, to be a role model for all who come after you, it is, I am so pleased, because I have to say, and you don't even have to agree or disagree, we have a lot of political appointments too that break my heart because they jump the line. You earned it the old-fashioned way. You were experienced, you were qualified, and you had all demeanor and temperament, and the most important, compassion and empathy. And when you can have a janitor call from a district court, never happened before, and it never happened since. So I want to say that, and it's a tribute to you. And I've been following you. Everyone says good things about you. I'm just sorry that I haven't seen you in all these years. But you look great. You look the same. And you do. You look great. But okay, now tell me about the nominee. How many times has Attorney Mulligan come before you?
You know, I haven't kept count. I sit 6 months a year in the BLS. And so in any sitting of 6 months, I will see her at least 2 or 3 times. You know, she has handled a lot of insurance cases. She handles these corporate matters. She's actually been a great mentor to young female associates. So sometimes she'll come in and it's clearly her case and her work, but she is allowing the female associate to argue, and she's kind of, and essentially sits there for moral support, having prepared that associate, which I really love, because I don't think young associates get that opportunity much. And Maureen was happy to do that, even though she was clearly the more senior and more experienced one.
Does any case come to mind that you were impressed the way she presented it?
Well, the one I had the longest experience on was that 2-week case. You know, I saw her every day, all day. And what was interesting is that she was with a more senior lawyer who, a man who was quite good, you know, in terms of, you know, speaking to a jury. But frankly, she was by far the more prepared. And I would always find her slipping him notes. She did most of the key examinations, so they worked together. But she supported him to kind of do what he needed to do, again from the background. And then when she was up, she was just amazing. I remember saying, "Whoa!" It was the first time I actually saw her in trial. Before it was, you know, kind of arguing motions.
So how many years have you known her?
Well, since I've been in the BLS, so it's almost 10 years.
Okay. No, your testimony means a lot, believe me. And I might be wrong, but I think this is the first time you've come.
It is.
Wow.
Well,
What took you so long?
People need to ask me. That's what I also.
Isn't that amazing? 20 years. Okay.
you know,
Well,
I
listen, I'm so glad that you took the time. I wish you were here in person. I wouldn't be able to give you a hug anyway, so forget that. But thank you so much for your time and for your valuable comments. Does any of the council, Councilor Kennedy?
Judge, it's good to see you. I haven't seen you for a while. Back when I was a young lawyer and you were a new judge, I used to try a lot of cases in front of you in Concord. I do want to touch on something that you're not going to catch me in the business litigation session, as you know, ever. If you do, I'm committing malpractice. But I just want to touch on what you said about criminal experience for the nominee. And I get that, and I get that we need people with civil experience as well, okay? But the thing that always concerns me, and it's something I asked the nominee, and I'm going to ask her again today, on the criminal side of things, is sentencing. Sentencing and bail, really, because what I have found over the decades that I've been doing this is when we get a new Superior Court judge who has strictly civil experience, they tend to take the safe route on bails and sentencing in the beginning of their career. And the safe route is they default to the prosecutor.
Excuse me, Counsel Kennedy, they're asking if you put
Okay,
your
I'm
mic
sorry.
closer.
Can you hear me, Judge?
Yes,
sorry.
I can hear you.
Yeah.
Yeah.
The safe route is to default to the prosecutor, when they're asking for bail, to, just accept what their recommendation is. And the same thing on sentencing, because I believe sentencing is more of an art than it is a science that people develop over experience, either as lawyers doing criminal work or judges over time seeing similar type cases and working through that. How do you think she's going to handle that part of the job? Because that's my biggest concern with people, and she will be doing criminal. She will not just be doing civil. Eventually, she'll be doing murder trials. How do you think she'll handle that part of the job?
Well, first, of course, she's not going to be handling a murder trial for a while.
Well, I understand that. I understand.
But-
Eventually, she will, though, in serious criminal cases.
Yes, and as you say, sentencing is more of an art than a science. We don't have a computer or calculator. We can figure out what the right sentence is. We have sentencing guidelines that help us a little bit, but it really.
I have no use for those, Judge, so
But
put
it
those
really,
aside, and how's she going to do it at looking at the
frankly,
person
it
in
has to
front of
do
her?
with what kind of judgment you think this person has. Is this person have certain, for example, I think the counselor was speaking about compassion. I think sometimes compassion has its place. Courage, sometimes the willingness to make a tough decision. Empathy, and that includes empathy for victims, because victims are heard at the time of sentencing. So it's having those kind of qualities that allow you to be objective and dispassionate, but at the same time understand those different voices. Because it's sentencing is a very, very difficult decision, sometimes very emotional. And I think it would be wrong for me to, close out emotions shouldn't have anything to do ultimately with my decision, but I have to understand the emotions in that courtroom and consider those as well. So I don't know, that wasn't said very artfully, but I think it has to do with what kind of judgment does a person have? And I think it also has to do with, does this person have confidence that and the commitment to make this kind of decision, and also the willingness to go seek out advice from colleagues, something that I did for many years. Even after having spent years in the district court, I would consult with colleagues and get a sense of how they might view a case. Not because I was deferring to them on the decision. The decision was mine, but they had experience perhaps that I could draw on, and how they had handled similar cases. It's something we talk about at our educational conferences all the time, sentencing. So colleagues are a big source of wisdom. But ultimately, it's going to be those kind of inherent human qualities that the person brings to the job. And I don't think a lack of criminal experience really translates into being pro-prosecutor or pro-defense. I really don't think there's a correlation there.
I respectfully disagree with you, Judge. I think that when judges start out, that come from the civil bar, I've seen it. They tend to default to the prosecutor. I've seen it over and over and over. I've been doing this now 37 years, and I've seen it a lot.
Well, I'm hoping that Maureen is going to be my mentee. She's assigned a mentor when she starts. I'm hoping I'm going to be mentoring her. And I can tell you, I would make sure that she would come into a criminal case without that kind of predisposed thinking. I think it's important to be very open-minded to both sides.
I hope she's your mentee too, Judge. It was great to see you again. Thank you for coming in.
Any other councils have any questions for the
Counselor?
judge?
Counselor?
Okay. Oh,
Judge, I would just like to say thank you for coming. We haven't met before, but we did also get a letter from Judge Fabricant last week talking about how important it is to have people that are well-versed in the civil matters, especially business litigation. And I know as a Commonwealth, it also helps attract big business to the Commonwealth, and we know we can resolve sophisticated, complex cases in the court. And I think she's a great person to fill that role. So I appreciate your comments here today. Thank you.
Thank you.
You're welcome.
I guess that no other questions. Thank you so much. I really appreciate you being here.
So I think
Oh, I'm sorry. Oh, Bob, I didn't see you waving. Okay, Councilor Jubenville,
Thank you.
now you're
Yeah.
gone.
It's good
Oh,
to
the
see you.
joys of Zoom.
It's good to see you, Judge. The bar in Norfolk has been crying ever since you left, because you do, and I've been before you many times, and compassion and empathy, you have so much of it, you should give some to some of your colleagues. But I would say, on the guideline issue, I take an objection to them whenever they're used. I recently had a plea in the Superior Court in Norfolk, and
Bob, we can't hear you.
Oh, I'm sorry, you're muted. Can someone help? Hold on, Councilor Jubenville, hold on a minute. You're muted. See if we can fix that. Hopefully, somebody out there.
sorry, the legislature is the only body to make a law and set the penalties for that law. The court system has never been given that authority to do that. And second of all, why the court system would ever get involved in 1 second.
His mailman came.
Uh,
1 second.
Is there any other counselors?
No,
I don't
sorry,
see anyone
sorry.
on Zoom, so please
Sorry,
shout out.
Sorry. It's the problems when you do these things at home. In any event, my objection is that the court system uses them, and I know every judge tells me they're just advisory, but I find that they're a starting place, an arbitrary one at that, either given by the prosecutor or the defense lawyer, depending on whether it favors them or not. So that seems to be the bar that you start at, up or down after that, which I think is unfair. Not only that, why the court system would adopt those after seeing what damage and destruction they did in the federal court system for 20 years. The unfairness of those guidelines were evident to anybody that practiced in those buildings. Also, I think they're unfair in this regard. The government gets to decide what charges a defendant is facing. And those charges set the bar for the guidelines. Some counties charge differently than other counties. So the defendant has no opportunity to set the charge that's going to rule in the guidelines, just the government. So I put an objection whenever they are brought up. I don't think they should be even talked about.
What is it?
There's no authority for them. And I think the court system is way out of bounds in getting a system that, I know the objective, one size is going to fit all, but that never works. You've been sentencing people for a long time. One size never fits all. So that's my objection on those. Other than that, I don't have any objection. I like the fact that this candidate is a very experienced civil attorney. And when I first started on the council, I remember there were a couple of judges from big civil firms. And I went to a judge in the Superior Court and I said, how can I vote for these people? They don't know anything about criminal law. And the judge said, Bob, we need civil lawyers. We need them desperately. So I understand that. I like to see somebody with a balanced approach, but it's not a deal breaker for me. And I suspect this candidate, in a very short period of time, will be in that business session, which is so important in the Commonwealth. It should be, and I think there should be more of them around the Commonwealth. Other than, what do they have now? 2 of them?
Yeah, there are 2 sessions. They're in
Yeah.
Boston. We've always contemplated expanding, but at this point, it's just Boston.
You know, it is one area you never hear any bad things about it. You hear nothing from business people other than good things. It's a marvelous court. So I suspect this nominee is going to be up there shortly. And good for her. She deserves it.
I'm hoping that I know that the chief always likes to have her a few years in the trenches, so to speak, but yeah, she would be perfect in that session.
Yeah. Thank you. Good to see you, Judge. Stay healthy.
Okay, thank you.
Bye-bye. Thank you.
Thank you, Counselor. Is there any other questions for the judge? Okay, okay, then we will say goodbye for now. How nice to see you. I hope it won't be 20 years again. Okay, our next,
Thank you.
Yeah,
I'll leave the meeting.
pardon me?
I'll leave.
I hear voices. Our next witness is Lisa Arrowwood. Welcome, Lisa, wherever you are.
I'm here. Good morning, counselors.
Oh, okay,
Um,
great.
Despite the strange spelling of my name that you see that seems to have no vowels, all of those P's are supposed to be O's. So my name is not ARP. Well, however you would say that. My name is Arrowwood.
Oh, okay.
although
I had 2 O's after the 2 R's. Is that incorrect?
It's ARROWOOD, but on the
Okay.
screen, those
All
O's
right.
are P's.
I had ARR. Okay. All right. That makes sense. I'm
Yeah.
sorry.
So although all of the counselors are known to me, I'm not sure that I am known to any of you. So I'll just briefly tell you, I've been a member of the Mass Bar since 1982. I started at the firm formerly known as Hale and Dorr. I then was a founding partner of the firm known as Todd and Weld. 2011, I started my own firm, which is where I am now. I'm a former president of the Boston Bar Association, and the Boston Bar Association is where I first met Maureen Mulligan 15 to 20 years ago. At a fairly young stage, she was co-chair of the litigation section, which was the biggest and most active section at that time in the Boston Bar Association. I was the co-chair of a subcommittee, the Tort Litigation Committee, and I met Maureen in that context, and her leadership skills were apparent right off the bat. My next interaction with Ms. Mulligan was when we were both members of the Board of Bar Overseers. I was a member of the board for 5 years, and I overlapped with Maureen for 3 of those 5 years. Although the Board of Bar Overseers clearly doesn't mete out criminal sanctions, the sanctions involved for any attorney who either is suspended or disbarred are fairly draconian, and in some respects worse than some criminal sanctions. Maureen was always one of the most prepared and engaged members of the board. She took on administrative roles in addition to the heavy caseload she carried at her firm. I always found her to be very thoughtful, analytical, but also very compassionate toward the lawyers who appeared before us, many in terrible circumstances in their personal lives, sometimes with substance abuse problems, sometimes with mental health problems. And Maureen was one of the members of the board who always saw that human side and showed her compassion towards those lawyers, and took that into account when she voted one way or another on discipline that the prosecutors from the Office of Bar Counsel were proposing. One of the things that was remarkable to me that year is I learned that in one of those years that we were on the board together, which has a very heavy workload, she worked on her just regular litigation practice almost 365 days that year. I'm not sure she even had a full week off. And she never showed that. She never showed the stress of it. The reality is that Maureen Mulligan is a workhorse. And to be honest, given the heavy workload of a Superior Court judge, that kind of ability to work is going to be great for the members of the bar. Just to give you an idea of how highly I regard her. So I've been practicing since 1982. I have been involved in a lot of bar association matters, and I'm a civil litigator, but I have a very broad type of civil practice. Everything from, close corporation disputes to medical malpractice cases and everything in between. And out of all the lawyers in the Commonwealth, when my own small firm got into a partnership dispute with one of the partners who is no longer in our firm, and there was some related litigation involving that partner, we reached out and asked Maureen to be our lawyer. So I know Maureen not only as a colleague, but also as a client. One of the things that is remarkable about Maureen is she is so calm and patient. And we got to see that in our firm because, needless to say, when you are the client and you're involved in a partnership dispute, emotions run high. Maureen Mulligan has the ability to stay calm, and she has a calm demeanor no matter how hot things get with lawyers on the other side. We hired her a second time when a former opposing party in a case that we had handled sued the firm in federal court. And Maureen, we got to see all of her pleadings. Her writing is impeccable, and got to see her argue in court, and she obtained a dismissal of the complaint. I also want to point out something that I think bears noting about Maureen. She has done an enormous amount, both within her firm, but also within the legal community at large and even nationally for women lawyers. She has a forum on women's issues at the Boston Bar Association. And I can't cite all of the leadership positions at the American Bar Association she's held, but several of them relate to women's issues. Somehow she manages to handle bar-related activities while having an enormous caseload. She also mentors women both within and outside of her firm. She will be a superb judge. As a civil litigator, I can say that one of the most frustrating things is to appear before a judge who really is having a hard time grasping the complex issues in some of the most difficult civil litigation matters. Maureen can analyze, has the intelligence and the breadth of experience for any civil matter that comes before her. As to the criminal matters, being the workhorse she is, I am sure that she has already been spending countless hours burning the midnight oil, learning what she needs to know, and she's not afraid to ask for help. I mean, I am senior to her as a lawyer. There are times she's had an issue in a case where she hasn't hesitated to reach out to me and ask me my opinion. I have no doubt that she will reach out not only to Judge Janet Sanders, but to other members of the bench anytime she has questions in any area of the law, but especially in the criminal area of the law. She is patient. She knows how to listen. As I said, she's an absolute workhorse. Her integrity is impeccable, and she has no arrogance. While I always am heard to bemoan the scarcity of top-notch women first-chair trial lawyers, and I do hate the idea of losing yet another one to the bench, Maureen Mulligan would be such an asset to the Superior Court that I can recommend her wholeheartedly. Thank you.
Councilor Duff.
Yeah, Attorney Arrowood, I am a big fan. Your firm has represented me one time and did a fabulous job. And you being here today is very significant. I agree with every single thing that you've said, in that she will make a tremendous judge, and the work ethic that she has is really second to none. So thank you for taking the in being with us. I appreciate it.
Thank you.
My pleasure.
Thank you, Counselor. Any other counselors have a question?
No, thank you.
Okay, then we'll go on to, thank you very much. I would like to ask you, so you are a civil litigator
Yes.
and you have your own practice?
Yes.
Good for you. I really, I know, I have, I have a special place for people who have private practice. I have my own theory. You aren't given the cases. You chose who you're going to represent. And if you believe in them, you'll take them as a client. That's why I have a lot of respect for the work that you do. How many years now have you been doing it?
It's so embarrassing to me to actually have to utter this number.
Well, don't, it
Although
won't
when
be
I see
embarrassing
myself
to
up
me.
there, I look that old. At this stage, it's 39 years.
Well, good for you. Good for you. Wasn't easy starting out then, I know.
No.
What case comes to mind that you know Attorney Mulligan, what she did and how you were impressed? Can you tell us a particular case?
Well, I think the cases where she represented our firm, particularly the second case was a very strange case brought by an opposing party in a case that we had filed. And it was this individual not only sued our firm, but also sued our client from that prior case and made all kinds of claims, including a RICO claim in federal court. And Maureen handled that case effortlessly. RICO is, not the easiest federal statute to understand. And Maureen did a fabulous job. She argued the motion to dismiss in front of Patty Saras, and she was very impressive. But I think one of the things that I just want to emphasize is how much empathy and compassion she had for us as clients, both in that situation, but also even more in the situation where we were involved in a partnership breakup and a partnership dispute. She has a huge heart and at the same time, an incredibly sharp analytical mind. And I got to see that as a client in the two cases she did for us.
That's great. How many cases have you been involved with her?
Only those two. I've never had a piece of litigation myself where Maureen was either a co-counsel or an opposing counsel, only being her client.
Okay. Thank you very much for your time. We
welcome.
really appreciate it. Thanks again. Our next remote witness is Alan David. Alan?
Good morning. My name is Alan David, and I'd like to thank the council for allowing me
I
to
see
speak.
two of you. Okay.
Pardon me?
That's okay.
All right. I'd like to thank the council for allowing me to speak on behalf of Maureen Mulligan. And I'm going to talk about two areas. First, my experience with her as a trial lawyer, and second, why I think she has the qualities to be a good judge. Let's talk first about the trial lawyer. I've known her for 30 years. She came to Peabody and Arnold, where I'm a partner, in 1989 as a summer associate. I think we called them clerks back then. And she joined the firm as an associate in 1990 and stayed until 1996 when she moved to California. But during that 6-year period, and mostly the last 3 years of that period, she and I tried together, I would say 7 or 8 legal malpractice cases. She was nominally a second chair in those cases, but when an associate tries a case with me, they do half of it. They do the witnesses, they do the examinations, they do the motions. So yes, technically she was second chair, but it really doesn't do justice to what her role in those cases. And 2 of those cases were significant cases that went to the SJC and established important principles of law in legal malpractice. Um, from a very early point in her career, it was clear that she had the technical ability to be a superb trial lawyer. That has been borne out. She is a superb trial lawyer. We don't try cases anymore. When she moved back to Boston in 2002, she went to another firm and finally came back to us in 2015. But, given the nature of law practice, you can't have two partners trying a case. But over the years, we've kept in touch with each other closely. We've followed each other's careers. And since she's been back in Boston, I've seen her try cases and prepare for cases, especially since she's been back with us since 2015. She is an excellent trial lawyer. And I don't think she would claim to be an appellate lawyer, but she does have significant appellate experience. And in the last 2 years, she's argued 2 cases at the SJC and authored 2 amicus briefs for the SJC. And not that it matters, but she prevailed on 3 of those 4. One thing I would like to touch on that both Judge Sanders and Ms. Arrowwood mentioned is her criminal experience. And she doesn't claim to be a criminal lawyer. Some may see this as an issue, but in her case, I don't think it is. I'm confident that she'll learn criminal practice quickly. And I have a real basis for that belief. And that is that over her career, one of her primary practice areas, if not the primary practice area, has been in legal malpractice defense. Legal malpractice is not about the law of legal malpractice. That's sometimes the least important part of it. It's always about something else. Legal malpractice doesn't occur in a vacuum. It occurs in a particular area of law: corporate, real estate, probate, criminal, civil litigation. You could pick any subject area you want that lawyers could get sued in. And if you're going to be effective in that area, you need to be able to master the law quickly to the point where you can discuss it intelligently and cross-examine experts in that area. And Maureen has always been able to do that. She is very effective as a lawyer in legal malpractice cases representing attorneys. And she has shown a repeated ability to master areas of law that she's not familiar with. So she's done this successfully for 30 years. And I have no doubt that on the criminal side of being a judge, she will master that seamlessly and quickly. Now, going on to her personal qualifications, as I see it, there are 4 basic things. We could disagree on the ranking of them, but I think there's probably general agreement on what the qualities are: intelligence, legal ability, dedication to the profession, and intangible qualities that you can fill in with any number of qualities. I'll fill it in with empathy. I've already spoken about Maureen's legal ability and intellect, and I don't think there's any need to go back over that. As for her dedication to the profession, I'll just mention a few things. She's been a member of the Board of Bar Overseers. She is currently the chair of the ABA Commission on the Status of Women in the Profession. She's on the Advisory Council for the Business Litigation Session in Suffolk County. She's active in the Boston Bar Association and the Women's Bar Association and the American Bar Association. And as both of the other witnesses have pointed out, she takes the mentoring of young lawyers very seriously. And as for the intangibles, it's hard to overestimate the need for a judge to be human and empathetic. I think there's this popular notion that judges are umpires who call balls and strikes. I think any of us who practice at any level of the court system know that that just isn't true. Judges operate in areas, gray areas, and they make decisions in gray areas that affect people's lives. I've known Maureen long enough to know that she gets that. In my experience, and I think almost everyone who knows her, she's kind, she's caring, she's generous with her time, especially to younger lawyers. She's respectful to everyone. And she knows that the decisions judges make, including her decisions, if she's confirmed, have consequences. Maureen is the best lawyer, the best partner, and the best friend that anyone could have. And I will miss her having her as my partner, but she'll make an outstanding Superior Court judge, and I urge the council to approve her.
Thank you very much. Any questions from the counselors?
Thank you.
Okay. So tell me, how long have you known, how many years have you known the nominee?
I've known her since 1989, so that makes 32 years.
Okay. So how many cases have you been involved with Attorney Mulligan?
I suppose it depends on what you mean involved. Actually, trying cases to juries, I would say 7 or 8.
Okay.
Involved in other ways, we talk a lot, and I am involved in cases now with her. But
could you tell me the 7 or 8 cases, what they were involved with?
All of them were legal malpractice cases. We were representing lawyers being sued for malpractice of various kinds.
And Attorney Mulligan was representing?
She was working with me as co-counsel representing lawyers and law firms.
Okay. Thank you very much. Thank you for your time. I appreciate you coming. So that concludes the witnesses. And so now I will ask if there's anyone in opposition to this nominee. Hearing none, we'll go on to our next section, which will be the nominee's opportunity for your presentation.
Thank you, Counselor. I appreciate the opportunity to address the council, and I'd like you all to know that I am very humbled and grateful to be here before you today. I want to thank the counselors for all the time that you spend reviewing judges for positions on to the Commonwealth's courts. I want to thank the JNC for their leadership, and particularly Lieutenant Governor Polito and Governor Baker for having the faith and confidence in me to nominate me for this position. Having appeared before the Superior Court judges for years, I can speak firsthand about the exemplary makeup of the court, and I would be privileged and honored to join them if confirmed. Here with me today is my husband, Carlos Fernandez, my biggest supporter, and our son, who is my greatest joy, is unable to be here. My sister and her family and my parents, all who would be here with me in the front row except for the pandemic. Thank you.
Excuse me, you could introduce your husband, that he is here. We do not have him on Zoom, he's in person. So if we could recognize him.
Sure, let's recognize my husband who's here with me. Thanks to my fabulous aunts, cousins, friends, and colleagues who have all encouraged and supported me through this process. As they say, it takes a village. In my conversations with some of you, you asked me to tell my personal story rather than just rely on the professional one that comes across in my application. So I wanted to tell you a little bit about who I am, how I got here, why I became a lawyer, and why I'd like to be a judge on the Superior Court. I grew up in Vermont, where my father was a book printer and later worked for the Postal Service, and my mother worked in various local schools. From my dad, I absolutely got my love of reading and an understanding that books can take you far beyond the horizons in which you live. This was the building block for my love of learning. From my mother, I learned to be courageous and bold and to challenge. My parents are both intelligent, compassionate people who did not have the opportunity to go to college, but made sure that each of their children had that opportunity. It's very important to me that their moral compass and continued support for justice in their own communities guides me still in my adult years. A few years ago, they made the decision to sell their home in Vermont and move in with me and my husband. Their friends and some family members periodically tell them how lucky they are to have their support, but truly, I'm the lucky one. Each day they make me laugh and they share their wisdom and their humor, and I am truly grateful that I get to spend part of each day with two people whom I love so much and who started me on this journey as I sit here today. I was born in Massachusetts and before moving to Vermont lived in Forge Village, a neighborhood of Westford. Forge Village at one time was a community of immigrants who for the most part worked in the mills. My grandfather, both grandmothers, and my dad as a young teen worked in those mills. Although the mill was closed by the time I was born, there was a kaleidoscope of cultures and languages on my street and in my broader world, where I heard English spoken with an Irish accent or a British accent, Polish, French, and Russian. Our move to Vermont brought us to a different environment, and my siblings and I loved growing up in a rural environment that allowed us to climb mountains, cross-country ski in our backyard, cross-country ski to school, swim in rivers, hang glide off of Mount Ascutney, and eat amazing food from the enormous garden tended by my dad and cooked by my mom. We had lots of adventures, but Vermont also has lots of poverty. For the first time, I was friends with kids who lived very differently than I did. Although they lived in homes that were rich in spirit, they were financially poor. I noticed this when I played at their houses or by what they brought in their lunchbox for lunch. In middle school, I decided I needed a more challenging academic environment, and I asked my parents if I could go to a boarding school out of state. The answer was a resounding no. This was a foreign concept, and they could not conceive of me leaving home, even for short periods of time at 15. Through some serious negotiation, we came to a truce. I would try 1 year at the local high school, and if I didn't like it, we would revisit the request. My sophomore year, I entered Concord Academy, thanks in part to my mom, who lobbied so hard for enough financial aid to allow me to attend. She knew her daughter needed this challenge. It wasn't until I became a parent that I truly understood the sacrifice that my parents made in allowing me to leave them for the school year at 16. I loved Concord Academy, and I know it gave me the academic background and confidence I needed to attend Brown University and Boston College Law School. But it also exposed me to an environment of uber wealth and privilege that I had never seen before. I married into a family whose first language is Spanish. My husband is from Uruguay. The first time I met my husband's family, I expected to meet his siblings, their children, and my husband's mom. Instead, I sat down to a table with all of those folks, plus the extended family of cousins, aunts, and uncles. At the time, I did not speak any Spanish. They tried for me to conduct the dinner in English, but that lasted all of about 10 minutes before there were many different loud conversations going on, all at the same time, all in Spanish. I was completely lost, relying on my then boyfriend, now husband, for periodic translations. Later that evening, my husband told me that his family wanted to know why he was dating such a shy, retiring woman who never spoke up. They did not think that I was going to last very long in their boisterous family. We laughed together at this description of his bold, outspoken, opinionated girlfriend. But over the years, I've thought about this experience often when I come across people who do not speak English but are trying to make themselves heard, about misconceptions that come from not being able to communicate or not knowing enough about someone else's world. My mother-in-law spoke very little English, a few words here and there. And when she would come to my house, she would Scotch tape pieces of paper on things all over my house, the refrigerator, the chairs, the table, with Spanish words over every surface. She wanted me to learn Spanish so we could communicate. She said she was my maestro. I have learned to speak limited, passable Spanish, enough to join the dinner time conversation with a bad accent and a limited vocabulary. But I am not fully confident in my Spanish language skills, and that feeling is so very different than the confidence with which I approach my everyday life. If I feel that way in the safety of a family who loves me, I cannot imagine what it feels like to come into a courthouse with English as a second language and wonder if you're able to make yourself heard. I'm sharing these stories about some of the environments I have lived in and experienced because I have believed that they have made me understanding of differences, have exposed me to many walks of life, and I hope they will make me pause as a judge to adjust my lens to the wide angle that is needed to embrace and understand the disparate groups of people who come before the Superior Court. I'd like to close with why I became a lawyer and why I hope to have the opportunity to serve on the Superior Court. As an elementary school student, I was passionate about a number of issues, but today I'm going to focus on gender equity. I was lucky in my 5th and 6th grade years to have amazing teachers who provided an engaging and interesting learning experience. We had a co-ed intramural after-school sports program, which had softball in the spring. In the spring of my 6th grade year, the boys on the team were talking about signing up for Little League for the summer. And when the forms were handed out in my science classroom, I asked for one as well. The answer was no. Girls do not play Little League. I took one anyway when the teacher left the room and sent my application to the town league. The answer was no again. Sometime after that, but before the tryouts, the 6th grade class had a career day, and one of the people speaking was a lawyer. I was fascinated by his presentation about the rule of law and how lawyers could help with the access to justice, and more simply, how the court system is the arbiter of disputes that cannot be resolved between individuals without intervention. After the presentation, I went up to him about my problem, the refusal to allow me to play Little League, and I said to him, maybe you can help me. I could talk for hours about the conversation that day, but I will fast forward to say that he represented me for free in filing a lawsuit seeking to get me and other girls access to the Little League team. During that time, Little League teams around the country were being sued, as was the National League, and ultimately a decision was reached in one of those other lawsuits that required the league to change its policy and allow girls to play. I was 12. It was my first lawsuit. But it showed me the power of the rule of law, the role of the courts in providing access to justice, and the necessity for the courts as places to resolve disputes that otherwise go unaddressed. One of my friends and I had tried putting petitions around town, riding our bikes miles to hang up the handwritten petitions in grocery stores, libraries, and other locations. I wrote to the governor, who wrote a very supportive letter back. To the president, who ignored me. I showed up for the tryouts, and I was turned away. I tried to convince people to support our position, but none of that resulted in change. It was a ruling from a court that resulted in change. And I knew right then and there, I decided I was going to be a lawyer. I have spent the last 30 years in private practice as a litigator representing clients in professional liability and complex business disputes. As an advocate on behalf of my clients, I have always appreciated the measured, respectful approach of the judges who have heard my cases. It's easy to advocate for a position. It's much more difficult to listen to all the evidence and issue a decision for one party. I knew when I made the decision to be a lawyer that one day, when the time was right, I also wanted to serve the public as a judge. That time is now. I would be honored to join those judges already sitting on the Superior Court bench and serve the Commonwealth and the people of Massachusetts if confirmed for an appointment to the bench. And I would work hard to make sure that everyone in my courtroom is treated equally and with respect. Throughout the course of my career, I have continued to work on gender equity issues by addressing the issue of gender and the intersection of racial equity and inclusion in the practice of law. I'm currently the chair of the ABA Commission on Women in the Profession, a leading source of research on the importance of and creator of tools for advancing gender equity in the law. I hope that this work, along with my own experiences of living in social and economic communities, of living in diverse social and economic communities, will make me a thoughtful judge, recognizing that not everyone's lens is the same, that the cases become before me should be evaluated on the facts of the individual matter and not influenced by whether someone is rich or poor, the neighborhood they live in, their gender identity, the color of their skin, or the language that they speak. I look forward to answering your questions today.
Thank you very much. With that, I'm going to call on the counselors who have any questions. I have been advised that Counselor Ianella has been having a lot of trouble getting in. His computer is not working properly. And so with that, I'm going to call on Counselor Ianella, if you can phone in now.
I'm here. No, I've been listening. I'm here. Can you hear me?
Yes,
Can
we
you hear
can.
me?
Yes.
Okay.
Okay,
Yeah,
just
thank you
talk
very
up a little
much,
louder, Counselor.
Thank you very much, Counselor Devaney. I don't have any questions. I was impressed with the nominee's witnesses. I was impressed with her presentation. I also had some communication with former legal counsel for the Patrick administration, Kate Cook, who speaks very highly of the nominee. That coupled with her experience, I want the nominee to know that next week when the council votes on her nomination, she can count on me to support her, and I wish her the best. Thank you.
Thank you, Counselor.
Thank you. Counselor Juvenville?
Thank you, Madam Chair. Good morning. Good morning.
Good morning, Counselor.
We had a nice talk. I'm not gonna get into too much. You heard my take on the guidelines.
Yes.
And I just think judges, first of all, don't have the legal right to use them and shouldn't use them in their courtrooms. Since they're advisory, you have the discretion not to use them. You know, there was a great federal judge, Judge Harrington, who refused to sentence people in the federal system under those draconian guidelines, he called them. He said, I'll go back to sentencing people the way judges have done it for 200-something years in this Commonwealth. And it's the things judges did all the time. Justice got done, people got sentenced appropriately without any guidelines. So I just make that pitch to you when you're in your courtroom. If you're going to use some guidelines made up by some committee, I'm going to bring in the Jubenville guidelines for you also, so you can consider those.
Thank you, Counselor.
The other thing is, have you read the Harvard study on the that Judge Gantz asked to be done on the racial issues in our court system?
Yes, I have.
Okay, so you know all of those things that you read in there, which were surprising, I'm sure, to a lot of people. All of the discrepancies in the amount of black people per population sentenced in our prison systems compared to white people in population. They're there because judges put them there. Somebody with a robe committed them. Nobody else can do that. And the answer for all of that was one word in the findings. One word was the answer: racism. That's why it happened. That's why it's happening. So I ask you to be aware of that, and maybe even take some courses. I don't know why every judge isn't required to take a course in racism to recognize that is so built into our system. I think some of us don't even realize it. And the other thing is, I think you'll make a great addition to the business session, the business court, they call it. That was started about 20-something years ago when Chief Judge Del Vecchio, I think, was the chief judge. Senator Bob Creedon tried to get a bill filed to do it, and Suzanne Del Vecchio started, I believe, the first business court. It has been a great success, and you'd be a natural for that. So stay in the civil, stay in the business court. You don't want to do criminal, it's okay. You're smart enough, you'll learn it. It's not an issue with me. So I wish you the best. I think you're going to make a great judge, and relax, and I think you're going to be voted on okay by this council. Thank you, Madam Chair.
Thank you very much.
Thank you,
Counselor
Counselor. Thank you, Counselor Juvenville. Counselor Duff.
Thank you. I really not only enjoyed speaking with you several times, Attorney, but I'm very impressed with your work on equity. And I thank you for that, not just as a young woman who was involved in a similar lawsuit when I was in high school to play sports, but also advocating for women in this profession. It's much needed still today, unfortunately, I have to say. But talking about your work, something you and I discussed very briefly was, and if you could tell us a little bit more about it, your work on intellectual property issues and technology. I find this to be something we need very much in the courts today. And as Massachusetts is one of the leaders in the country, I'm very, not just pleased, I'm thrilled to see this as part of your background. So could you share a little bit of some of the work you've done in that?
Sure. Most of the work that I've done in the intellectual property area has been representing companies in the digital media space and in internet type of disputes. I call it internet theft, but it's not a crime. It's when one company is using something of another company by purchasing or using particular keywords that would then drive traffic to, the wrong site. So using someone's trademark to drive traffic to their site. In terms of the digital media work, that has been primarily, I'll just tell you about one case as an example. So a digital media company had the rights to broadcast, the rights to broadcast in the United States, some media or films that were made outside this country. And the way that in digital media that you make money, there are a couple of ways. One is you charge a subscription, and the other it's free for people. It's click through. People click on ads. And so I represented a client where as soon as this information was uploaded, somebody was downloading it to the torrent and then uploading it to YouTube and playing it for free, which obviously did not allow the company to monetize it through their subscription program. So those are the types of things that I work on. I think it's really interesting because in the sort of digital economy, the way that companies monetize their business is very different than traditional brick and mortar stores. I've also done some traditional trademark and copyright disputes, but the digital media and the internet disputes have been my primary source of that work.
Yeah, I find it fascinating stuff, and it's we can almost not even, we can keep up with it, but it would take a tremendous amount of work to not just keep up with it, but frankly, for a lot of people to get up to speed on it. So I think that's great that you come to us with that. What do you see, other than funding, which I think we all agree with, what do you see as the biggest challenge facing the courts right now? Because we're grossly underfunded.
Right. I think because I'm coming before this council after the length of time that the pandemic has kept the courts either closed or not able to operate as they normally do in terms of the amount of cases that they prosecute. I think one of the biggest challenges is the backlog of trials, particularly criminal trials. And the question is, what is the court going to do to move that forward? And I think there are some limitations. We're limited by some very old courthouses, some courthouses that are not appropriate for social distancing. And in fact, there are other procedures that need to be in place if you're going to try a case during a pandemic. And so I think the immediate challenge for the court is figuring out what to do about that backlog of cases and how to get through those trials. Having said that, I would like to hand out kudos to the judges and the court administrators who have worked so hard to keep cases moving on motion practice and discovery, and offering alternatives with 3-judge trials and other types of things, and bench trials in order to keep cases moving. It's been a spectacular effort, but having to move the trials forward, I think, is going to be the biggest thing facing the court in the next couple of years.
Thank you. That is frankly very true, and thank you for sharing it. I'd also like to, if any of the court people who work in the courts, judges are watching or listening, I'd like to concur in actually thank them for the work that they're doing right now. It is tremendous, the challenges that we're facing. And for any of the legislators that are watching or listening, we desperately need more funding to build courthouses that are accessible to people, that people can actually get to, so access to justice is actually accessible. And part of that means having the wireless technology capabilities, because some buildings cannot be retrofitted. The things that we need today are much more advanced than what we can possibly do to retrofit buildings. And this is a very, very critical issue. And frankly, I consider it a major public safety issue as well. But access to justice, really, we can talk about it, but if people, one, can't get to court, if they can't get into court, we need to find a better way of doing it. And with technology today, we had to embrace it, and we've learned some good lessons from it. So thank you for saying that, because I really want to let especially the chiefs of the different courts know that we do appreciate, or I appreciate, everything that they're doing. You know, I could go on and talk and ask you more questions, but I really don't feel I need to. Your writing is exquisite. That's something I think it's important to me, having a liberal arts education, but it's also important in the Superior Court as well. And you not only seem to like it, you're very good at it, and you do also have a good liberal arts education. I'm going to guess somewhere along the line you probably took the art of critical thinking, because you clearly are a very good critical thinker. And I really have no other questions for you, Attorney. Thank you for applying it. It's really been a pleasure to get to know you a little bit and speak to you. That's all, Madam Chair.
Thank you
Thank
very
you.
much, Councilor Duff.
Thank you.
Councilor Kennedy?
Thank you.
Counselor
Good
Devaney?
afternoon, I guess.
Oh, shit.
I just have a few questions for you, not too many. Spoke on the phone. Incredibly impressive resume. How many trials would you say you've done?
18, 10 jury trials, and I say approximately 8 bench trials because there may have been a few early in my career that I've forgotten about, but 18.
That's I know that in big firms that a lot of cases don't go to trial, and that you have a lot of litigators that do a lot of litigation, a lot of motion practice, and most of the cases settle. So I think that's a pretty impressive number coming out of your background. We've had many people here from big firms that, you know, they may have tried 1 or 2 cases to jury verdict. It doesn't mean they don't have a lot of litigation experience in the civil side, but not necessarily jury trials. So I think that's very impressive. Just to get right to my point, which is the criminal law part of it.
Right.
That's primarily what I do. It's primarily what Counsel Duganville does. I know that Counsel Ferrara does some, and it was certainly his background as a police officer and police chief that he was involved in that part of it. I do a lot of civil stuff too, but the criminal to me is more important because you're dealing with people's liberty. Somebody's going to go to jail, and that's a big deal. What happens to judges over time is they become desensitized to how big a deal that is because they're sending people to jail all the time. How are you going to handle sentencing, bail issues when you first get into the criminal session? Because as I said to Judge Sanders, and I've tried many cases in front of Judge Sanders, and I said to you on the phone, new judges that come out of your background, and I've seen it over and over and over, safe route, it's the default to the prosecutor and their request.
So I don't think I'll ever forget or ever not know what it's like to send someone to prison. I have been inside the Suffolk County Jail before it was the Liberty Hotel, in representing, I'm not claiming to have any criminal experience. I just want to tell you about the impact that it had on me to go into the Nashua Street Jail and into the holding cells when I did a clinic. When I was at Boston College Law School, I did a clinic with the Public Defender's Office for a semester. And in those instances, we were meeting our clients in the holding cell in the bottom of the Dorchester District Court. And at that time, the women's holding cell was not the same as the men that had the bars and all the guys were in one and you talk to your client through the bars. The women had a door that was closed and you were locked in there with your client. And so I have never forgotten the impact of what that felt like to be locked in there or to walk through the Nashua Street Jail in order to get to the attorney room to meet my client. But my approach to sentencing, which I am sure will evolve if I am appointed to the court, because there is so much that I have to learn about sentencing. But as I sit here today, my approach is that the judge who is sitting to make the sentencing decision needs to take all of the information into account that is presented by the attorneys, by the victims, by everyone that testifies at the sentencing hearing in order to make a decision. And judges need to balance what the rehabilitation and the punishment versus the safety of the community, and what is the best decision for that particular individual. And that's how I would approach sentencing. If I'm appointed as to the bench, will spend a lot of time talking to my fellow judges about the sentencing process, what they find to be important, different things that have helped them along the way. But the one thing I will do is listen to both the prosecutor and the defense attorneys who are presenting the information for sentencing.
Yeah. There's a lot of, in my opinion, overuse of 58A dangerousness hearings in the system. Prosecutors, frankly, I think file them more to cover their backside than really to have people held. And they're filing them in countless cases, and they file bail revocations in countless cases. I don't know if it's bail revocation, I'm sure.
Yes.
But are you familiar with them? Let's start there.
Yes, I understand the difference between a bail hearing and a dangerousness hearing.
Okay, are you familiar with dangerousness hearings?
Yes, I am.
Okay.
I'm not familiar with them because I've done them. I'm familiar with them because I've been reading cases about them.
But you've been prepping for this? Yeah.
I absolutely
Okay.
have.
Yeah. I will never doubt for any matter you handle, you won't be well prepared. And I would never doubt that you have been well prepared throughout your career. But dangerousness hearings, I think, are really, really overused. I think there's a lot of alternatives to incarceration. And we've had what I consider a nightmare going on since the pandemic. The SJC, as you've read, I'm sure, if in Superior Court, when somebody's found dangerous, they can be held for up to 180 days. And there are exclusionary periods to that. Any time excluded under Rule 36, which is speedy trial, would be excluded from that period of time. The SJC stayed that during the pandemic because trials can't get done and motions can't get done. So there are people sitting in Massachusetts jails right now that are sitting there indefinitely with no end in sight and no end date, no trial date, no tolling of that 180 days in Superior Court, 120 in district. And they're just sitting there and no way to get out. And some judges are considering that. The SJC has said it stayed, but judges can consider it on a reconsideration of bail if the length of time that they're being held is turning into something that's excessive. Most judges don't let them out because they already found they were dangerous. So we have people sitting in jail in the United States of America, in the Commonwealth of Massachusetts, no idea when they're going to get out or when they're going to go to trial. What's your approach going to be towards dangerousness hearings, and do you believe that they're overused by prosecutors?
I don't have any basis to know whether they're overused or not because I have not been in a criminal courtroom to make that assessment. But taking your statement for what you're saying, My approach would need to be to listen to the evidence for the dangerous hearing and make a decision based upon the evidence that is before me. And to follow whatever guidelines and rules have been put out by the SJC.
Okay. Now, most of the trials you've done, from what I can see, or a good number of them have been legal malpractice cases, right? A good number? Involved in a
And
good
business
number?
disputes for the trials,
Well, talking about legal malpractice cases.
right?
Your partner,
Alan David.
talked about the fact that they involve something other than just the standard of legal malpractice, because you have to learn about the underlying case to determine if the lawyer committed malpractice, or to be able to defend a lawyer who is accused of it, right?
Correct.
And that would involve potentially criminal cases. Have you handled any that involve criminal cases? Do you remember?
Well, I have written a brief involving a criminal case, but I don't believe it was a legal mal. And I have defended officers and directors of some banking institutions where there were also criminal-related charges, and we were working with criminal attorneys on those cases. But I don't recall, other than being peripherally involved in providing some advice to other people in my firm who were representing lawyers who were acting in the criminal space. I don't recall off the top of my head a specific one that I directly did regarding criminal law.
Okay. I just want to comment on your mentoring of young women. It's not just young women, you've also mentored young men as well.
Yes.
I received a call, as I told you, from one of those who I know very well, Lincoln Rose, who's at your firm, previously a prosecutor in Essex County, who talked about how you took him under your wing and really mentored him from the day he started there. Very, very impressed with you. He's somebody who I have a lot of respect for. It's a young man, young lawyer. And so it's not just women, but I do admire the work you've done for women in the law, because it's something near and dear to my heart, because I have a daughter who's a 31-year-old lawyer. I'm very, very proud of it. Everybody in this room knows that. They hear me talk about her all the time. So that's very important to me as well. And I think, and I hope that to the extent you are allowed to continue in that role as a judge, that you continue to be involved in that area, because I think that women still have a long way to go. There's still an old boys network out there to a certain extent, and hope you stay involved in that. I'll be voting for you next week.
Thank you very
for
much.
all the time you gave me over the last couple.
Thank you, Counselor.
Your parents live with you, correct?
They do, and hopefully they were able to log on this morning and watch this on Zoom.
Well, I appreciate the fact that you came in here live, given that they live with you, because they're older, and I know that they'd be at substantial risk with this pandemic, with or without a vaccine. So I appreciate that you came in here live, and I hope that that they stay healthy.
Thank you. Appreciate that.
Counselor Pereira.
Thank you. Thank you so much. I don't know, I know we're supposed to have assembly around 12:30, so just tell me when to stop and I will.
No.
Okay, thank you. I appreciate it. Well, thank you. You and I spoke a couple of times at length, and although I think you and I would have preferred to get together personally, I do respect the fact that you have two of your parents living with you, and you didn't want to, expose them to anything. So I certainly understand and appreciate you talking to me by phone.
Thank you.
I really respect the fact that you filed that lawsuit. I have three daughters myself. Did you get to play softball or Little League?
Unfortunately, I aged out, but a large group of girls got to play the next year on that team.
Oh, good. All right. I was going to ask you a batting average, but we can't go there. So I do appreciate all your contributions. And I spoke a little bit about the letter we got from Judge Fabricant, the chief of the Superior Court last week, who tells us that over the last 10 years, the analysis is that 80% of the cases filed are civil. So 80% and about 55% take up the time in the courtroom. And she, went on to talk about how necessary it is to have great people with great civil litigation, complex civil litigation background it is. And some people in my office have told me that they've had a great working relationship with you at Lynch & Lynch, and that you're an outstanding person and very good to work with. And I really take to heart what they say, because they do stuff that I don't do. You and I had a conversation. One of my pet peeves in the civil world, and I don't think you did a lot of it, is medical malpractice.
I have not done medical malpractice.
Yeah, my biggest pet peeve ever, and I'd ask you to keep it in mind, is when the defense lawyers come in and say, I'm sorry, I'm not available to try that case for 2 years. And I'm the only guy in the office that can try that case. I'm the only woman in the office that can try that case. And my next available date, Judge, is 2 years, 2.5 years from now. When plaintiffs, sometimes their clients are elderly, sometimes people are going to die. And I say it truthfully, and although, they ask for the basis, but that's the defense lawyer's dream in a med mal case, that the person dies because it automatically curtails the damages on a case. And I see him do it, and I see him get away with it, and it just irks me that judges don't say, choose someone else from your firm to try the case. We're not waiting another 2 years. We recently tried one that was 6 years old from the time we filed the case to trial. And I think that's disgusting because plaintiffs don't get their say in court. They're dead by the time the case comes to trial. So I'm done talking about that. But I appreciate the fact that, and it doesn't always happen, that you're just taking a huge pay cut, which says a lot to me. It's not always true. It can't always be true, but it says a lot about you that you want to give back to the public, and it's not about money for you. So I love your resume. I love your personality. I think you're going to make an outstanding judge. I think you're going to contribute lots to the Commonwealth of Massachusetts, and you definitely have my support next week.
Thank you so much, Counselor. I appreciate that.
Thank you.
Counselor Devaney?
Hurley?
Yes, thank you. We spoke at some length.
I don't see you. I don't see you, Judge.
Okay. It's going to be ugly because I dropped my iPad and it's all crackles. The screen is all cracked.
That's okay.
So
you on your phone? Are you on your phone?
No, I'm on Zoom, so I could see everybody else. But
okay.
Adam, if you want to start the video, I'll go back live. Adam.
I'm here, but we cannot start it. The video from our side has to be from your side.
Okay, I'll try again. It says sending video is disabled. So be that as it may, we talked, Attorney Mulligan, and the second time that we talked, you had taken me up on some of the types of books / the internet things you should be looking at in terms of criminal law. I'm very glad that at the second time that you in fact had taken advantage of my suggestions, and when I first took a look at your application and found out that basically all you did was civil, I was a little bit concerned because where I come from, it's not a 50-50 split. If we have 5 Superior Court courtrooms going, 1 is civil and 4 are criminal. But Boston is a different region, and the specialty court that you have there, I think, speaks significantly to the recognition of the need for civil specialists to sit on the bench and give a fair shot in those kinds of civil trials. I also appreciate your upbringing and also the glowing statements that have been made about you today, especially by Janet Sanders, because she and I served on the bench together. So your son is not there today, I understand that. But my question to you is, if he was there, what would he say about you?
He would say my mom loves being a lawyer. I'll tell you just a brief story, and hopefully he's not listening by video because he'll be very embarrassed. But one of the struggles I think that moms have is being a mom and being a full-time lawyer. And I think that it's the example that we set for our kids that makes them accept what we do. And one time when I came home from work, my son was about 8, and he said to me, "Oh, Mom, I'm glad you're home. I have something I want to talk to you about." And I had had a terrible day at work, and it sounded like he had something very serious to talk to me about, which he didn't. But, and I said, oh, I should just quit my job and stay home. So when you come home from school, I'm here. And he looked at me, 8 years old, and said, why would you ever want to do that, Mom? You love practicing law. And from that point on, I never felt that guilty about going to work, and always knew that he was getting exactly what he needed.
Great. And you've got a very insightful child as well. So after our discussions, which included sentencing and bail and criminal law and different topics within that, and your very impressive application, all I can say is I think that you were smart not to have your parents there. I have several medical issues, and I don't want to take the risk either. So I intend to vote for you next week, and I think you'll make a fabulous judge.
Thank you,
Thank you.
Counselor. I appreciate that.
Thank you, Counselor Hurley. Counselor DePaul.
Thank you, Counselor Devaney. Good morning,
Good
Attorney
morning.
Mulligan. It's a pleasure to meet you in person. I won't iterate some good comments and questions asked and answered this morning already. But I do want to note that I've spoke to several people and received a phone call praising you and your attentiveness in particular to your clients. And it's duly noted. And I think it's so important that we have folks in the Superior Court with a background in complex civil litigation as you've engaged in, and I can appreciate the pressures of that work and balancing it with your activism in the bar community, especially around gender equity and your family. That speaks volumes to me about your ability to be well prepared and to be a conscientious judge. I did want to ask a couple questions around sentencing, issues that overlap with sentencing, some of which came up, some of which didn't. I'm wondering your experience or your knowledge around mental health and addiction as it intersects with our criminal system.
So as Lisa said in her statement, in serving on the Board of Bar Overseers, we see a lot of lawyers whose bad decisions stem from mental health or addiction issues. And so I have had an opportunity to see how that can impact someone, a decision that someone is making. And I used to say when I served on the Board of Bar Overseers that we see very few bad people come before us or bad lawyers. What we see are people in crisis who have made bad decisions. And so in direct response to your question, because I haven't practiced criminal law, I have not been exposed to what percentage of people who are coming before the court have mental health or addiction problems, but certainly have read about that.
And when it comes to mental health and addiction, and there are quite a few folks who come through in the criminal side who are dealing often with undiagnosed or untreated. And then if they're sent to a house of corrections, I'm not sure if you're familiar, but the Department of Justice recently issued a report, a rather scathing report about the Massachusetts Department of Corrections and the civil rights violations over mental health access, treatment, access to mental health treatment that prisoners in Massachusetts are subjected to. So I think that's an important, I guess, layer of context to consider when you're thinking about sentencing. And it overlaps also with the juvenile courts and the paths that folks get on when they enter the system there and at that age. And I'm wondering what you think about raising the age of juvenile jurisdiction, whether you think that's appropriate and out there.
I know that there is some science out there that discusses the, sort of age at which the brain really develops to make informed cognitive, choices. And I don't have an opinion on that because I don't know enough about it, but I do understand there's science out there, and it's certainly something I'd be interested in learning more about.
Yeah, absolutely. And you're right to note the science is pretty overwhelming, especially in the male brain, around brain development and executive functioning, and that lasting well into the early 20s. And so another factor perhaps to consider in sentencing. And then finally, it came up already this morning, but around the racial issues in our court, I just want to put a point on it because you are potentially going to be seated in the Superior Court. And what you know from the Harvard study is that Black and Latino defendants are more than twice as likely to be referred to Superior Court, even when there's dual jurisdiction between district and superior. And obviously, once you're there, you're potentially exposed to higher sentencing. And what we see in the report is that the really substantial differences in sentencing, even when controlling for all the factors we know, it's happening almost exclusively at the Superior Court. So I'm just wondering if you could talk about how that informs the kind of judge you think you'll be, and how you would attempt to address whatever implicit bias either you may bring or that the system has already brought by the time of defendants before you.
So I think one of the things that is most important for judges is when you come out onto the bench, we have to be very aware of what our own implicit biases are. We have to be conscious and ask questions to ourselves about where our biases lie, so that we don't let that influence how we might consider and rule on a case. There's a lot of data in that report that you're calling the Harvard study, some of which is not, some of that data, there weren't conclusions reached because there were either holes in the data or they weren't able to get good enough data to continue to do analysis. But I do think that it's a very informative report, and there certainly is more analysis to be done about what that, how the courts are going to respond to what's in that. And I look forward to those conversations.
Yeah, you're right to note. I agree with you that there was data that would have been very helpful that was either not available because it hadn't been collected or not available to the folks conducting the study. I have no further questions. As I said, I think it's incredibly important to have folks with complex civil. So I intend to support your nomination when we vote as a council.
Thank you, Counselor.
Thank you, Counselor. Well, welcome.
Thank you.
First of all, I was very impressed how you have been a mentor for other attorneys, and especially for women. And you spearheaded the women in the insurance group, is that right? Yeah. And I did want to pick up on, you talked about your 8-year-old son, and out of the mouths of babes. I have 4 children, and I didn't have the opportunity to go to college until after I was married with 4 children. We lived from paycheck to paycheck, but my husband got a loan. I wanted to be a teacher. But you know what? Never got a job in a public school because every time I got interviewed, they'd say, "You have 4 children. What do you do when they're sick?" So all those women out there who talking about breaking the glass ceiling, I broke it for you. But I just wanted to say about comparing your 8-year-old to my 6-year-old. Is it too loud? Oh, you couldn't hear? You couldn't hear me?
I can hear you.
Okay, so one day I brought my 6-year-old, my son Tommy, to school with me. And when we were walking out to the parking lot at the end of the school day, he looked up at me and he said, "Mommy, what are you going to be when you grow up?" So it is funny, the mind. The other thing is, I really resent the science that says your mind, the brain, is not developed till it's 25. We have seen so many cases in the past years of teenagers killing, raping their teachers and next door neighbors. And for me personally, I resent it because I figure I got a pretty good mind, and I chose to have 4 children before I was 25. So I resent that. That's book knowledge. I'm talking about life experience. And every time someone sits there and tells me that, it really bothers me. So I'm just venting. So thank you. The thing is that, you know, I have a big concern right now. And a lot of the judges are learning. The SJC has to learn. And I've asked them if they would have a task force to educate, to learn about foreclosures. Have you ever been involved in any foreclosures?
No.
This is something that probably 20 years ago wasn't a big priority before the courts. But believe me, I get the calls, and I know personally what people are going through. And it's a terrible thing because the judges are allowing fraudulent foreclosures on homes when they don't even know the identity of the one they're dealing with, the representative on the other side. So, you know, I hope that you will look into that. You know, I have said to the SJC lawyers, and I hope that they are following up and having a task force. It's something judges have to know. In this pandemic, housing is the biggest problem for people. And to have your home taken from you, I can't even imagine. You know, for myself, alone as a widow, I can't even imagine. I wouldn't even know where to go, what to do. So I hope you'll look into that, okay? The other thing is, as far as the legislators, I have said it for years, the judiciary in the budget probably gets about 1.5%, and it's wrong, especially in this climate where there's so much crime. We need more drug treatment centers. I've said it every time. And also, you know, moving Cambridge Court to Woburn. The average person doesn't have a car. How do you get there? The whole thing is upside down, and I can't even imagine the rent that they're paying. So you have nothing to do with that, but I just want you to know the circumstances that I feel as a governor's council that I have absolutely no control over. Okay. Now I'm looking at your experience, and you were 6 years at Peabody and Arnold, and business disputes, professional liability defense, and insurance coverage litigation. 3 years with Roberto, Israel, and Weiner, and complex business litigation matters, technology, digital media disputes, trademark, banking, commercial, shareholder disputes, professional liability, and insurance coverage disputes. 4 years with Bob Stein and Blackman, and you were involved in business litigation, professional liability, defense lawyers, accountants, directors, officers, and other professionals. Sedgwick deterred Moran and Arnold for 1 year, and you represented lawyers accused of violating security laws regarding issuing partnership interests in PCS technology companies. You have experience that I think is needed in the courthouse. But as I told you, I can't just put it aside. You have had not one criminal case. And when I talk about drug addiction, you know, you have no experience or foreclosures or any of those things, violation of 209As, all of those things. And so you have to learn on the bench. And that troubles me because I think that you're a very intelligent person. I like that you care about especially women, to mentor them. I wish I had someone to mentor me. I had nobody, and I never had the opportunity. So there are a lot of people that if you didn't help, they wouldn't be a practicing lawyer. They wouldn't be successful. So you're a great mentor and you care, and I like that. On the criminal side, I'm concerned, and I'll tell you, my biggest concern is sentencing. I have a theory, maybe it's a philosophy, that if you have a judge that has never had criminal cases as an attorney, they will be timid, they will be reluctant to give the proper sentence because they've had no experience. And that is an awesome responsibility, to just be there, never having any criminal cases, to do that. And I have been following, and I have to say I'm very sad that the best police commissioner Boston has had, in Bill Gross, that he is leaving. And he has told me, I've sat with him, how he has brought in real bad criminals. Criminals that attacked a woman while she was walking her dog and she has brain damage. And the district attorney had the judge call it a misdemeanor. And that's what the judge called it. Those are the things that bother me, because that judge has to make really, life-changing sentencing. And I don't know whether you can. I have no reason, because you haven't had one. And I'll only advise you, please, in this pandemic, there are a lot of courses you can take, remote, whatever. But I am imploring you to really, really learn criminal. Your resume is off the mark. I mean, it's great. The things that you've had, as I said, we don't see that. But my concern is representing people, representing an individual person that's before you. You are representing industries and corporations and lawyers. Tell me, how are you going to meet that need?
What need are you talking
Well, I'm
about?
talking about, people in my 21 years, people that are sitting where you are, they have been representing individuals for, 25 years or whatever, and different cases. Maybe it's child abuse, maybe it's murder cases, or maybe it's, some fraudulent cases or whatever. But I'm just saying that I don't know how, when an individual, a regular person, comes before you, how much experience have you had when it's. See, the thing is, I guess on an aside, I love people in private practice. I just think going to a bench, being in practice, private practice, you were given all your clients. You didn't go out and seek them. And when you are in private practice, you seek out who you want to represent or you don't want to represent. And I think that experience goes into the court. And even on a practical matter, because you're responsible for shoveling the snow and paying for the rent. So maybe you have a different philosophy when someone comes in, a client, with a lawyer, and you know what lawyers are getting per hour, and you know how hard that is, that you have a more sensitivity to that person and to the lawyer representing that client. And, I don't know the flexibility, but I hear so often that everybody comes in at 9 and all of that. There's got to be a way where we can accommodate people that are paying and that are, just regular everyday people. So that's the concern I have in my mind about you, that you haven't had, maybe you've had one or two, I don't even know, but that doesn't seem to be in in the experience working for these firms. So that's it. So you've never really been on your own. Now you're going to be. And you're not going to have a partner. You're going to be alone. And people are going to be coming before you with cases that you can't even imagine.
Pardon me, councilors. The Lieutenant Governor has joined us.
Oh, the Lieutenant Governor. Oh, I'm sorry. We're going to break for our public assembly with the Lieutenant Governor presiding. And I will continue after the assembly. So you can take a seat with your husband, and it won't be too long. So we will take a break. Thank you, Lieutenant Governor.
Thank you, Councilor Devaney. I apologize for the delay. We finished up our visit to the mass vaccination site in Danvers and announced 2 additional vac sites in Natick and in Dartmouth today. So that's good news, good progress. So we call our assembly to order, and I recognize Councilor Kennedy for our prayer and pledge today.
We'll just ask all of us to take a moment of silence for all the victims of the terrific pandemic that is ravaging our entire population.
Okay, I recognize Councilor Jubenville for a motion to record advice and consent for the financial warrant.
So moved.
Second.
There's a motion and a second. All in favor, say aye.
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 And I recognize Councilor Ianella for a motion to record advice and consent for the pending list of notaries, public and justices of the peace.
So moved.
There's a motion and a second. All in favor, say aye.
Aye.
I recognize Councilor Jubenville for a motion to record advice and consent for the appointment of William Trevon Bailey to the position of Associate Justice of the Cambridge District Court.
Aye, so moved.
Second, and I'd like to be heard.
Yes, there's a
Lieutenant
motion
Governor?
and a second. Councilor Devaney.
Thank you, Lieutenant Governor. I just want to make a comment about Attorney Bailey. This is a man so compassionate and caring about the people he represents and his family. And when he was in law school, a young law student, his mother got into financial problems and was going to lose her home. And what a time for a young man. And he stepped in and filed bankruptcy. He went into a lot of financial problems personally, but he did that for the love of his mother. And I saw that and talking to people and what they said about him. All of his pro bono work is amazing. It really went on and on in his resume. And that tells me what I look for: compassion and empathy. And so I did want to register that today, and I'm very proud to vote yes.
Madam Lieutenant Governor?
Councilor Hurley.
Yeah, I actually had the pleasure of having Trevon Bailey appear in front of me when I was a judge in the district court in Western Mass. And he was always prepared, always polite, always courteous, and really sincere. And those, I think, are the kind of qualities that we need in judges. And I am thrilled to be able to cast a vote in favor of him today.
Thank you, Councilor Hurley. Okay, we have a nomination and a second, and a motion and a second, and we can begin the roll call.
Councilor Jubenville?
Yes.
Councilor Devaney?
Yes.
Councilor Ianella?
Yes.
Councilor Duff?
Yes.
Councilor Kennedy?
Yes.
Counselor DePaulo,
Yes.
Counselor Hurley,
Yes.
Counselor Ferrera,
Yes.
veto, Governor.
Thank you. We have two nominations today. Sharon Lally has been nominated to the position of Associate Justice of the District Court. Counselor Jubenville, do you have a date and time for the hearing?
Yeah, I'm gonna put that on for the 24th of February, Lieutenant Governor. I don't have a time yet. But I will get a time very shortly.
Okay.
I just want to
And-
check with her and some other things.
Yes.
But
We'll get back. We'll make sure everyone is aware of the time on the 24th for Sharon Lally. There's James Murphy has been nominated to the position of Associate Justice of the District Court. Counselor Devaney, do you have a date for this hearing?
Oh, the 31st?
I don't think there is a 31st.
Is that a
February.
Wednesday?
We're in February.
28
now.
days of February.
Right.
Oh my
so-
God, oh my,
Huh?
20,
I know that, I know
30,
you don't realize this, but there's no 30.
So that would
30
be
days
third.
in September, April, June, and November. I'll never forget that.
So
I
March
forgot
3rd?
we're in February, of course. So that will be, believe it or not, that would be probably
Have to be March 3rd. would be
first
the next
of
one.
March.
March 3rd would be
March
the Wednesday.
3rd is a Wednesday.
Is it-
March 3rd is the Wednesday.
Okay, I don't have a calendar, thank you, Counselor, and it's March 3rd, the first Wednesday in March.
What
Do you
is
have a
his name
time?
again?
His name is
And
James
that would be,
Murphy.
and excuse me, and the time would be for the hearing at 11 o'clock.
Okay,
And what's his name again?
James Murphy.
Thank you.
And on February 24th, Counselor Jubenville will circulate a time for Sharon Lally. On March 3rd, James Murphy at 11 a.m. Okay, that concludes our business today. Thank you. Have a great afternoon.
Sammy,
Thank you.
Appreciate it.
Thank
Bye-bye.
you.
Okay, we will resume our hearing. I always ask the nominee their journey coming here. Okay, so you applied November 2019. Okay, now you have applied twice to courts. Could you tell us about that?
So I first applied for a position on the Superior Court bench in, I think I filed the application in August of 2015, and I was offered an interview in October of 2015. At the time I was offered the interview, I had just accepted a position as a partner at Peabody and Arnold. And I think I was a little bit naive when I applied the first time because I understood that you needed to apply multiple times before you would advance. And so I was starting that process. Didn't expect for it to go that quickly. And I had an opportunity to work with some people that I had grown up with in the legal profession and to work with a great team of associates, a firm that had a lot of young women so that I could put into practice some of the things that I was doing on a more national scale. And I decided to do that. I declined the invitation to interview with the JNC and explained to them my reasons for that.
Okay, tell us about the second time that you applied. That was in 2000.
November of 2019.
Yeah.
Right. As I said in my personal statement, I have always wanted to be in public service and be on the bench. And I had been waiting for another opportunity to apply. Some positions opened up on the Superior Bench, and I applied in November of 2019. I then had an interview with the JNC shortly after the July 4th weekend of 2020.
Okay, this was after you, your second time, this is the third time you applied?
No. The November of 2019 is the
Okay, that is-
application
all right.
before, that I'm before you
Okay,
today.
that's the final time.
Yep.
Okay, so just for the public, 21 lawyers have an awesome responsibility that the governor has given them, and they are charged as a member of the Judicial Nominating Commission to decide who is going to be interviewed, who's going to be recommended to the governor for a lifetime position. Now, they are charged to investigate and all of that. So it's they have more authority than any of the council. We have one person to vote on yes or no. We're not even allowed to be told how many have applied, how many have been interviewed. So I want that out because a lot of people think we have such authority that we have a list of people and we throw a dart at a dartboard. I don't know. So tell me, how many of those 21 lawyers appointed by the governor were at your hearing?
I didn't count, but I understand it was half the council, which I would assume would be 10 or 11.
Okay, so my whole point is that with this awesome responsibility, 10 of them never met you, never saw you, didn't investigate, didn't call you, and voted for your appointment. I don't hold that against you. I hold that against the JNC. There was a JNC chair years ago, and I was told that he told those 21 lawyers, if you don't appear at the hearing for that nominee, you are not allowed to vote on that nominee. Isn't that great? That's my kind of government. But I just want to throw that out, just informational, and it doesn't have anything to do with you. So, okay, so what happened after that? Did you get a letter or to come back to see the governor to tell us about that?
You mean after the interview with the
After the
JNC?
interview, yeah.
At some point in time after the interview with the JNC, I received a phone call inviting me to interview with Bob Ross, governor's chief legal counsel. After that, I interviewed with the lieutenant governor, and then I interviewed with the governor.
So at that time frame from November 2019, and you had the interview, what month?
I had the interview in July of 2020.
Okay. So, all right. So then how long after did you hear that you were appointed from the July date?
I believe my interviews with Bob Ross, the lieutenant governor, and the governor were in September of 2020.
Okay. So we got letters for you, and they were, they were very impressive. They're like 3 pages, so I can't read the whole letters, which I really would like to, but I just want to tell you that Jane Horn gave us a letter, and she worked with you for 5 years. She's known you for more than 5 years. You worked at Peabody and Arnold together. Is that correct?
Yes, we're still there together.
Okay, yeah. And it was a beautiful letter. She said, professionally, Maureen has helped shape me into the lawyer I am today. I had the pleasure of assisting her with several of her cases. And despite being well junior to her, she always made me feel that I was integral to the provision of legal services to the client. And, the readiness to learn from others will make her an asset to the bench, as it shows that she will have great respect for those who came before her, as well as not just a willingness, but an eagerness to consider the positions of others. She goes on how you are a great mentor, and you've won awards through the years because of your mentoring. And she said, this speaks volumes about who she is as a person, personally and professionally. And she said 3 things that comes to mind about you: fair, brilliant, dedicated. And for these reasons, Maureen will make an outstanding judge. And so, outside of that, Peabody and Arnold, she said you have been involved both local and national level, and took her along. And I mentioned it, your local women in insurance group that you spearheaded. She mentioned that and how you have helped young professionals along the way. And, she just has accolades about you. And she said that we would be very lucky to have you as a judge. I like to hear that. I like to hear that, you know, you're helping other people along the way. From Jane Tyrrell, from Mass Interest on Lawyers' Trust Accounts. And she talks about that you are an excellent lawyer and litigator with extensive experience in the courts, and you have distinguished yourself by using legal talents and providing pro bono services for low-income individuals and public service organizations. That means an awful lot to me. And so, so in doing that, you have served as an executive director on this Interest on Lawyers' Trust Accounts organization.
If I just want to correct you, I don't want that to go in the record incorrectly. I have never been on the board of the IOLTA committee. I have represented them in efforts to bring funds to the IOLTA committee.
Okay, well, she gave you one more plug. She said you're executive director of the Massachusetts IOLTA, which is Interest on Lawyers Trust, and an active member and frequent chair of the Mass Boston and American and Women's Bar Association, dealing with issues affecting legal services for the poor. That means a lot to me, that you care, that you have compassion. I won't vote for anyone if they don't have compassion or empathy, and I've said that all the time. And so I think the one good thing that has come through the past few years, that we have mentors now and judges. And I think that's wonderful, because I have got calls about, especially one young person that became a judge, and mentoring them, because there's some that are rude and so forth. I won't go into all of it, but the mentoring program has worked, because I used to get complaints about this young woman, and she had no court experience. She had 22 hours a week at home. So you know how she got the job. But anyway, let that go. But I've heard she's getting better, and the mentoring is working. Have you heard about that program?
I do understand that new judges are assigned a mentor, yes.
Absolutely great. And maybe in time you could be doing that, you know? So anyway, you know, so she said you organized a major conference for the Boston Bar Association on women in the law. I think that's terrific. And so she said that, you know, all of the things that you've done, you've argued in Superior Court for this organization, and to be chosen for the recipient of residual funds and class actions. In one case, where the plaintiff's attorney argued that the residuals should revert to the defendant, and you persuaded the court that reversion was unacceptable because it would defeat the law enforcement purposes of the class action procedure itself. As a result, the committee has been able to provide this mass MLAC, that's a different one, MLAC, and 2 bar foundations with millions of dollars in new support for legal service programs. So, you know, it's outstanding what you have done and taken leadership, and I like that. In pages that go on, she's got three full pages, and so what she is saying, in essence, you've been a mentor to her in her career. And when you founded the Boston Bar Association Women's Advancements Forum, she had the opportunity to see your commitment to mentoring women in the profession on a larger scale, that Maureen is dedicated to making sure that women and people of color can achieve success in the highest positions of the profession. She worked tirelessly to coordinate a series of speakers and opportunities for lawyers at all points in their career to meet and discuss barriers and opportunities for advancement. And she just said that, you know, all of the things that she has done, you know, that you've been her model. You're the model of civility. That means a lot, because I've seen some and I've heard some things from judges that is not civil. Your briefs are well-written, measured, and persuasive. I did appreciate your writing. It was good. Her oral advocacy was confident, respectful, and reflected deep and firm grasp of the law and practical implications of her arguments. And so, you know, she's worked with you over 9 years, past 9 years, and she said you would be a remarkable judge, outstanding wisdom, judgment, written, oral, analytic skills, a formidable work ethic, and a wonderful personality to the position. She would work tirelessly and with compassion for others and dedication to the law that will benefit the trial court and the Commonwealth beyond measure. I recommend her without reservation and with enthusiasm, if I can be of any further assistance. And so I think that's is that the last one that I had? I had June Horn, and Jane Terrell, Mary Strother. Okay. So I do want you to know, and the public doesn't know this, and the nominees don't know, we're not allowed to see the letters of recommendation that are sent to the JNC for the nominee. That's too bad. And I think that nominees think that, but it's not true. So, so these letters, you know, really mean a lot, especially to me. And they will be, you know, and they will be put in the file, in your file, in our office. And I, you know, it's just, I'm looking for Strother. I didn't find that. I know I have it. Lisa Whittemore. And said that she's known you for over a decade through volunteer work with the Boston Bar Association. That you're talented, dedicated, a leader, high integrity, deeply cares about others in the legal profession. She devotes too many hours to count towards supporting. I'm sorry, you can't hear me? You couldn't hear me? Oh, you didn't hear that at all? Oh, okay. So anyway, Lisa Whittemore has said that you deeply care about others in the legal profession. You dedicated hours towards supporting and encouraging other members of the legal community. And she said she met you previously and she got to know you well after she became a chair of the BBA's litigation section steering committee over a decade ago. And she talks about your generosity, spending time providing guidance and insights to her, and that you had been the chair prior to her. And she said she sees you time and again selflessly take on the role as advisor, mentor, leader to benefit of the profession as a whole. And I have no reservations in supporting Maureen's nomination for a position on the Superior Court bench. And you know, I think that, you know, these are very heartfelt, that, you know, these letters. And, you know, I've read a lot of them, and some of them really don't know that person so well, and you can almost tell they know you. And this is very heartfelt, these. Now, for Mary Strother, am I pronouncing it right? Strother, I'm sorry. Now, Mary is writing because she said she's known you for 4 years serving on the BBO. And she's known you since 2011. And she said you were closely reviewing disciplinary matters, overseeing various administrative functions, and Office of Bar Counsel. And she said that you have been an inspiration and mentor to her. And she said your love of the law, exceptional judgment, and compassionate approach to issues will make you a strong addition to the judiciary. And she said on the BBO, you were one of 12 volunteers appointed by the SJC to administer and oversee the entire lawyer disciplinary process in Massachusetts. That's a great asset that I see in you to take the bench. And as a mentor for people that you serve with, not everybody that comes through here is really qualified, majority of them are, but we had someone to the Superior Court 4 years ago that had 6 cases in 21 years in the Superior Court. That doesn't meet any test on me. And also the council voted while we were interviewing him, like I'm interviewing you. Lieutenant Governor came in, they voted. So these are the things that I do not, I feel are unethical, and I am not part of that. And so that's why, to see your honesty, that you're coming here honestly, and these people, you know, they're not big heavy hitters. These are people in a legal profession that know you, and that they took the time to send these heartfelt letters. And, you know, she says you exhibit deep and broad legal knowledge. You understand the law surrounding lawyer discipline, but you also have an impressive vast knowledge of the variety of practice areas. Lawyers who came before the BBO for disciplinary action practice in every conceivable area, including criminal law, estate planning, tax, real estate, bankruptcy, business litigation. Maureen questions in analysis of each disciplinary case reflected outstanding of each of these areas of practice beyond most lawyers with her background. So, you know, it really, I mean, you're chair of the Rules Committee, all of these things it'll be an ask for you to be on the bench. And she is a first assistant attorney general, Mary. And she said that she had the opportunity to review your briefs drafted on behalf of the Massachusetts, and that's at IOLTA,
The IOLTA committee.
committee in opposition to positions taken by her office on behalf of the treasurer, and watched her argue before the SJC in connection with that case. And your advocacy for her clients was superb. As an opposing counsel, model of civility. Her briefs are well-written, measured, and persuasive. Oral advocacy for confident, respectful, reflected deep and firm grasp of the law, practical implications of her arguments. She finishes by saying, based on the various opportunities I have had to work with Maureen and seek her counsel over the past 9 years, I think she would be a remarkable judge. She would bring outstanding wisdom, judgment, written, oral, and analytic skills, a formidable work ethic, and a wonderful personality to the position. She would work tirelessly and with compassion for others and dedication to the law that will benefit the trial court and the Commonwealth beyond measure. I recommend her without reservation and with enthusiasm, if I can be of any further assistance. So, you know, having said that, tell me now, when you have taken, you know, this position on the BBO, have you ever taken a strong disciplinary position against a lawyer? I know some of them, it's not, you know, criminal, it's per se. So maybe you can tell us about that,
Well,
because I really don't know what cases you had on that. We didn't discuss that.
Sure. So as you know, the Board of Bar Overseers is the entity that oversees lawyer discipline. So complaints can be made about a lawyer by their client, by someone in the community, by a judge. And if a complaint is there may be some preliminary investigation by bar counsel. And if a complaint is open, then what the members of the Board of Bar Overseers do is there are many, many things that the board does, but the disciplinary hearings are not heard by the Board of Bar Overseers. The disciplinary hearings are heard by a 3-person panel of lawyers from the community, and then the Board of Bar Overseers determines whether the sanction that has been decided in that disciplinary hearing is the correct sanction to recommend to the SJC or not, because the SJC has the ultimate power to decide whether to accept or reject a sanction. The other thing the board does is we hear appeals from those disciplinary hearings to determine whether or not, based on the facts that are in the record, the decision is warranted. the Board of Bar Overseer members also hear reinstatement hearings. So someone who has been suspended for more than a year or disbarred needs to have a reinstatement hearing to get their law license back. And those reinstatement hearings are heard by members of the Board of Bar Overseers. There are way too many cases that came over the course of 4 years for me to even, talk about all of them.
No, you're bringing a lot of knowledge to the bench that a lot of other, attorneys have not had that ability. I only want you to bone up on some criminal cases and really, if there's some way that you can do it remote or whatever. And I think that would be round it all out, because you absolutely have covered everything as far as I'd like to see as I said, we haven't had someone that's represented cases like you have. So you are, everyone has high regard for you. And I think even to your personality, I think that's wonderful, because people are afraid to go into a courthouse and to approach that judge. And the judge smiles or shows, that they have compassion. That means a lot to me. So I thank you for all your time. This is a very difficult time to go through this pandemic. And certainly, you'd like to bring more members of your family and because of the pandemic. And I understand that. And I appreciate he's not here. I'm the only one left here. But, I appreciated the prayer today for all the people who died of coronavirus, because as I told you, my sister died in a nursing home of coronavirus. So I think that we have to be so aware of how to go by all the regulations, as hard as they are. I hope the governor will bend a little bit on the restaurants and things, because I've had dear friends closed their places up for auction, restaurants, bakery, florist. It's heartbreaking. So I hope that we get through this. And now, what is happening in the Superior Court? Are they loosening up on these regulations? What will happen when you're appointed? How will you bench? Will it be remote? Will it be?
I don't know. I haven't had any conversations with that yet. I certainly don't want to get ahead of myself. I have this
Sure.
hearing. Let's take one day at a time.
Right.
And if the council sees fit to confirm me as a judge, I'm sure I'll be having many conversations with the court about how that will work. But as a practitioner, I have been having mainly remote hearings with the court. And I don't know what the plans are for the court in the future,
Okay.
how they're going to continue that.
Well, I just want to say, I am alone. No one's on Zoom. No one's here. So I don't think there's any more comments. But I
It's
am
not
very
true,
impressed.
Marilyn. People are here.
I can't see you. Why don't we see Counselor Duff? It's all blacked out, Counselor Duff.
That doesn't mean we're not here, Marilyn.
Oh, I apologize. And why is that we don't see Counselor Duff on the
There
screen?
are other councils here as well.
All right. Well, thank you.
Don't
Thank you for
understand the
thank you for
technology.
hanging in. So next
And
week.
Counselor Devaney, I am here as well.
Okay, good. I hate this Zoom. I see black screens. I'm sorry. Anyway, I do want to tell you that next week I will be putting your name for nomination, and I will be very proud to do that. And I don't always show my hand, but I am going to be voting for you. And I think you'll be such an addition on that Superior Court that you will, as you have mentored all these people from their letters, that they will be looking to you for advice on these cases that they have never heard or seen. But I would like you to look into those foreclosures, because they're coming up in the Superior Court. And unfortunately, some judges don't understand, and some of these people are not being treated correctly because of the unknown representatives that are there in opposition from New York and other places. So I have said enough, and I'm going to adjourn now. And I thank you for coming. And I thank my counselors on Zoom, Counselor Hurley and Counselor Duff, who are there, and I know you're out there somewhere. But anyway, so
Thank you.
thank you. And I'm going to adjourn right now.
Thank you very much. I appreciate your
No,
time.
thank you.